Hi, everyone. I already see people in the chat. Hello.
Welcome, everyone. We're just going to give folks a couple extra minutes to join us tonight, and then we will get started. Okay, welcome, everybody. Um, so glad to see all of you here at our webinar tonight, Unpacking the PROTECT Act. My name is Liv Santoro, and I'm the Deputy Field Director for Civic Education and Mobilization at the ACLU of Massachusetts. Before we get started tonight, just want to review a few housekeeping items. First, we would love to hear where all of you are calling in from tonight. So please take a minute to introduce yourself in the chat box with your name and your city or your town. We are going to save the last 10 to 15 minutes of tonight's presentation to answer your questions. So please use that question and answer feature rather than the chat box to submit them along the way so we don't lose track of them. And we will be sharing a copy of tonight's slide deck following tonight's presentation. I see people introducing themselves. We've got New Bedford, Medford, Heath, Charlestown, Springfield, Hyde Park, Somerville. Love to see folks calling in from all over the state. Lynn, Melrose. Awesome. Let's keep those introductions coming as we get a little bit underway here. So, as all of you know, one of the reasons we're here is because last week Governor Healy signed the PROTECT Act into law. And the PROTECT Act is a crucial step to establishing meaningful protections for Massachusetts residents against ICE abuses. And tonight we're going to talk about some of the highlights from this bill and what that means practically for our communities. Now, we know that the PROTECT Act is not a cure-all for ICE abuses in our state. And we can both celebrate this historic victory and recognize what the bill does and what it doesn't do. And we're going to get into that more throughout tonight's presentation. Behind every legislative victory is years, if not decades, of work, and that often goes unseen and uncelebrated. The PROTECT Act is a victory not just for our lawmakers, but for all of those who organized and mobilized over many, many years. Importantly, the passage of this law is not an endpoint. It provides a new launch point for how we think about immigration policy in our state, and we'll talk more in tonight's presentation about the work that comes next. So now I want to turn it over to my colleague, Laura, our Senior Advocacy Director for Field Initiatives, to get us started tonight.
Buddy, thank you so much for joining us. Glad to be here with Liv. I'm Laura Rotello here at the ACLU. Thank you for spending your evening with us. I know that everyone wants to get right into what is the Protect Act, and we will get to all of that. We want to start by sort of contextualizing the Protect Act itself, where we are in a national context, in a state context. How did we get here? Many of you have been around for a long time and have seen the progress of bills like the Protect Act. Want to sort of take a step back and look at how we got to this moment. And then, of course, we'll get into the meat of it, what is actually in the Protect Act. And rather than going through sort of section by section, because it's such a long bill, we've broken it up into thematic buckets. And we hope that that's sort of a better way, or at least an easier way to digest that information in just a 1 hour webinar. So then we'll get into what does it mean in practice? What are the real implications that we might see coming out of the Protect Act? And of course, what is next for all of us as advocates? So the first part of it is really important to step back and look at the context of the Protect Act. And just to remind ourselves, what is it? What is this bill that we're talking about? It's called the Protect, which actually stands for something. It stands for an act promoting rule of law, oversight, trust, and equal constitutional treatment. It's a groundbreaking piece of legislation. It's comprehensive and it consolidates multiple bills that were on the floor already, that were proposed even as late as this year and late last year, and executive actions from the Healy administration into one unified legislative framework. And it's kind of massive. It is 16 major policy sections and then a bunch of sections about timelines for implementation and details under one unifying theme, which is, of course, mitigating the harm of Trump's cruel deportation program in Massachusetts. And when we say that, it's important to remember that we are just a state, one of 50, and we are one state legislature and can only do so much from our state point of view, right? So this bill tries to do as much as possible to to really take our state power to curb these abuses, knowing that the federal government is going to do what it's going to do, and this is all going to play out. And so, just take a step back. What does the nation look like right now? These states highlighted in blue are the ones who have some form of a state law that limits collaboration with ICE. That could be a ban on 287Gs. It could be a ban on communications. These all look a little bit different from state to state, but you notice the pattern here, right? We've got the West Coast, Colorado, New Mexico. We've got a lot of the East Coast. I have not shaded in Massachusetts on this map, but as you know, we are now going to be shaded in. Illinois, smack in the center. Virginia, Delaware, Maryland, New York. Now contrast that to the states that have done the opposite. And so, as a marker for that, we're looking here at states who have signed up for the 287G program. Why do we look at that program? Because that is one of the most extreme forms of collaboration between states, cities, towns, counties, agencies, even with ICE. The 287G program allows a municipality and agency to essentially lend its own personnel to be deputized as ICE agents. And you can see the proliferation of these around the country. When the Trump administration took power on January 20th of last year, there were 135 of these around the country. Today, there are over 2,100. And you can see that the proliferation really has been led by Florida, Texas, and some of the southern states. Just one more time, let's go back one one map, right? These are the maps that are these are the states that are trying to protect their immigrants by opting out of that voluntary collaboration. And these are the states and localities, because these are not all state level agreements, who are opting in to help ICE. And so that is the context in which the Protect Act lives. We are not the first state to try to do this, but we are certainly more in line with these states than these states, right? All right, so how do we get here in Massachusetts? And this is a moment to celebrate and to really think about what brought us here. And as Liv said, it's been decades of advocacy. Many of you, if not all of you, have been there. Every time we packed that Gardner Auditorium, every rally in the cold, in the rain, in the heat, every time we made our voices heard over the years, that has all led up to today and then the work that's going to continue. Here's another picture I found on the top left. Look at how crowded that A1 room is. That was back in 2017. That was a hearing for the Safe Communities Act. You can see Sheriff Hodgson, who's no longer sheriff of Bristol County, in the middle testifying. You will remember those long hours sitting on that carpet, sitting in that hot room, giving testimony of affected community members, of people from all walks of life, like faith leaders, lawyers. We had everybody testifying every time you sent a postcard, every time you called your legislator, every time you accompanied somebody to an ICE hearing, every time you became an ICE verifier. All of this has come together to the moment that we're in right now. And again, more work to be done, but I just want to highlight how much we have done. Just some more pictures. You'll remember some of these hearings and some of the standouts that we've had all along the way. And in terms of Massachusetts, one of the things that we really want to highlight is that there were bills, several bills in the state legislature that really set the stage, and that municipalities also led the way. So if you see the top right corner where you see Jamie Eldridge standing in front of the State House, that was 2013 when we first filed what we call the State Trust Act. And that was built on a California law, 2013, so 13 years ago. Then in 2015, Lawrence became one of the first cities to pass its own version of the Trust Act. Of course, in 2017 was the first Trump administration. He takes office. Newton begins to kick off a wave of municipal policies that try to do a lot of what the PROTECT Act is doing, protect its local resources from being volunteered to ICE. In 2017, the Trust Act became the Safe Communities Act. Then the Supreme Judicial Court decided what is called the Lund case, where they said that actually police do not have the authority to hold somebody on an ICE detainer, so to hold somebody just for an immigration offense. That was all in 2017. Fast forward a little bit more. 2022, we passed the driver's license bill. You'll see at the bottom left one of the rallies. 2023, more bills were filed. Dignity, Not Deportations, led by Christine Barber, Rep. Rogers, and Senator Gomez. The Access to Justice bill by Chair Day. The Safe Communities Act continued to be filed. And then in 2025, we had even more bills that all, including the I-9 audit bill, access to courts, and more. And then in 2026, we see all of this being consolidated into the PROTECT Act. So, the meat of it, what is actually in the bill that was signed into law? We're going to look at just some highlights. Again, 16 sections. I won't be able to get into all of the details, and we'll put in the chat. The Mirror Coalition did an excellent fact sheet. If you want to look at detail by detail, section by section, we'll put it on the chat because it's a fantastic resource. But three essential buckets of themes. The first one is limits on state and local assistance to ICE. That's like what we can do to limit how we help ICE. The second is limiting civil arrests in sensitive locations. And the third is the expansion of rights and tools. And these are the tools that are going to give us the opportunity to enforce this very law and to enforce the other rights that we have. Some tools that we did not have in our toolbox and some tools that got expanded. So I'll take these one at a time. The first one is the limits on state and local assistance to ICE. Off the bat, it's important to notice that this law says that there cannot be using of state or local resources for civil immigration enforcement. That is a really important catch-all to say whatever your policy is, whatever you're going to do, if you're using your local resources to help civil immigration enforcement, you can no longer do that. And that is going to encompass a lot of things. We may not even know at this time what that's going to encompass, but it's a really important baseline to say our local resources are for local needs. We're not going to help civil immigration enforcement. And that was language that mirrored the very early municipal policies and like the very early California and Illinois state legislations. Then we have some limits on sharing non-public information with ICE. The kind of information that ICE really wants from police are like, when is a person in your custody? When are they about to go to court? Where can I grab them? Police can't just give out that information. There are some exceptions for when ICE sends a request in writing. It has to be a specific person that they're looking for, so there can be no fishing expeditions. It's not a full ban on sharing information, but there are more limits than what we had in the past. And then there's specific kinds of assistance that are getting banned. So can't hold a person on an ICE detainer. That's very much a codification of the Lund decision. Police can't stop, arrest, search, or investigate a person for a civil immigration enforcement situation. Once again, can't use their resources, but even if they're not using resources, they just can't do any of these things. In continuing with the limits on state and local assistance, police generally can't ask about immigration status or citizenship. I know that in many of your cities and towns, this is a best practice that they follow already, but it is now codified. There's one exception, and it is a limited exception meant to help, especially people who are victims of human trafficking. So, if police are investigating a human trafficking crime or another felony, and immigration status is directly material to that felony, so not just any felony, but a felony in which status has something to do with it. So, whether you are undocumented and a victim, especially, they can ask you about your status or your citizenship because it's important to that particular investigation. We're going to see how this plays out in practice, but it is a very limited exception, so we hope that police will not use it generally. And then, of course, the big white whale, the ban on 287G agreements. This is something that has been in the Safe Communities Act for a long time, in Dignity Not Deportations, in Rep. Cabral's bill. We don't want any more of these agreements. Now, the exceptions. There's a limited exception for any police department who wants to sign one of these, but it has to be a 12-month contract. There's a lot of hurdles to jump through, and it has to be only about criminal matters, not about civil immigration enforcement. Currently, that's not possible. 287Gs are, by definition, about civil immigration enforcement. And so currently, this is not a possibility, but we need to be honest that there is an exception there, and that if the federal law were to change at some point in the future, some, police department could try to sign one of these. They'd have to jump through a lot of hoops, and it would allow us to hold them accountable along the way, but it is a possibility, even if it's very remote. And then, of course, the Department of Correction gets to keep its current contract, but can't expand it without some further hurdles. And I want to pause there because I know we get a lot of questions about what is this 287G contract that the Department of Corrections has? Why did the legislature allow them to keep it? What is this all about? So I'm just going to pause here and do a little dive. So the 287G contract at the Department of Corrections was signed back in 2007 by Governor Patrick. As I said, across the country, they've ballooned and, there are over 2,100 across the country today. Importantly, this is not a detention contract. So this contract, there are no ICE detainees at the Department of Corrections, and I just want to be clear about that. What it is, it's also not a street level enforcement contract. The DOC officer who is assigned to the 287G program does not leave the DOC, is not out in the streets making arrests. What it is, it's an administrative contract. There's an administrator at the DOC who, when somebody gets brought into the Department of Corrections, they get processed for immigration violations. And once they wrap up their sentence, that officer ensures that the person gets sent seamlessly to ICE. Most people in the DOC custody are serving a sentence greater than 2.5 years. Now, the PROTECT Act doesn't end it, but it does include more guardrails if the DOC ever wants to expand it. And it's important to note that the legislature is not the only way to end this DOC contract. This contract could be ended today by Governor Healy or the DOC commissioner. So if you feel strongly about that, and I know that we at the ACLU do, and we have opposed this contract for a very long time, reach out to the governor. There's a lot more advocacy to be done there. It didn't happen in this bill, but it doesn't mean it can't happen in the future. So that is that contract. Back to those three buckets. That second bucket is courts in sensitive locations. First of all, it bans civil arrest, any civil arrest. So this is an arrest that has nothing to do with a crime. There's no judicial warrant inside and outside of courthouses. So that covers the inside area. It also covers the plazas, courtyards, walkways, driveways, around the area where we know ICE officers might be hanging out. So it also bans civil arrests at schools, which is broadly defined, health facilities, and daycare centers. It includes a set of standardized guidelines that we're going to see in the future, rules and protocols for what to do if ICE comes. And it allows the Attorney General to enforce any violations if ICE does come and make a civil arrest in any of these locations. This was a really important piece for advocates who worked on it for a long time. We know, especially in courts, how many arrests happen there. Now, will this be effective in the short term? We don't know. We've seen that in other states, ICE has abided by it, and in some states, they just haven't. In the Illinois context, they did place a ban, and ICE was violating it. So we need to see how this plays out. We see that the Attorney General is going to be the one to enforce these violations. And so you have a role there to play in that if you're a loose labor verifier, if you're a court watcher, and you see ICE making a civil arrests in these contexts, you can speak up. You can call the OSA hotline. I imagine that they always take these calls, and the Attorney General should be ready to look at those reports. Okay, number 3. This is what I'm calling the expansion of rights and tools. These are tools that are going to allow us to enforce this law and our constitutional rights. First off, detainee rights. This is something that people like the Prisoner Legal Services, CPCS, fought for very hard to ensure that people who are detained by ICE in our jails have more explicit rights. And right now, this applies to Plymouth County Jail, which is the only jail in the state that has ICE detainees. So it includes things like once you come into the jail, you get notified of your right. You're told that you don't have to talk to an ICE agent. You're given a daily call to your attorney. You have access to remote hearings, which was spotty at times. Importantly, there's a custody tracker. If you've ever been with a family whose loved one was picked up by ICE and they don't know where they are now supposed to get a 6-hour call, a call within 6 hours of the person arriving at Plymouth County Jail or leaving Plymouth County Jail because they're being transferred elsewhere. That call within 6 hours is a game changer for families who are desperately looking for their loved one. It also includes language access and other things that are just going to make things a little bit better for those held in ICE detention at Plymouth County Jail and if there's ever another contract. Okay. And then this is also a really important piece that's called Reverse 1983. It refers to a federal code called 42 USC 1983. That federal law allows people to sue when their constitutional rights have been violated in federal court. Of course, we know now how difficult it can be to bring a lawsuit against an ICE officer, a federal officer, in federal court. So what this law does is it allows individuals to bring a lawsuit in state court against state and federal officials for constitutional violations. So if we see what we saw in Minneapolis and people have been harmed by ICE agents or other federal officers, they can now bring a lawsuit here in Massachusetts for those constitutional violations. Okay, some wonderful things that also made it in is if you're an employer and you're being audited by ICE, you have to give notice to your employees. That gives them a heads up and an opportunity to make sure that their paperwork is in order. UNT visas, these are visas for victims of crime. There's some updates to that. I will admit I'm not an expert in this field at all, so I'm going to leave it to our amazing partners and other organizations to tell you more about this. Same with guardianship. There's some changes to the guardianship paperwork that you might be filling out as you prepare your family for the worst case scenario of a loved one being deported. There's also a section that requires an audit of detention facilities. Again, currently Plymouth County Jail by the state auditor. How are they spending the money that is coming in from ICE? What are they doing with that money? And we want to see those papers. So that is another accountability tool. And there's going to be a standing legislative commission on immigration. So this is not the end for the legislation, for the legislature, which, we know that sometimes when they do something very difficult, it's hard to get back in there and make changes, make updates. There's going to be a standing commission on immigration that includes many partners, many nonprofit partners, law enforcement, legislators who can bring these issues on a regular basis to the legislature. Okay, that was a lot of detail. I want to mention quickly, what does this mean in practice? Like any other major bill, it's going to take time. We are not going to see this come into effect immediately. In fact, there's a cascading set of dates of when each section becomes operative. But even after they become operative, you know that it takes time. It takes time for everybody to adapt. It takes time for the guidelines and the training to happen. And that is where you're going to play a role as well in terms of accountability. So what can we expect in practice? Back to our three buckets. When we talk about limits on state and local assistance to ICE, this is an area, first of all, we're not going to see any more 287Gs. That should be done. It's going to codify some of the best practices. Some municipalities are going to need to adjust how they do things, especially local police departments, to meet these new standards. Others will already be in compliance and may want to go further. This bill does allow municipalities to go further. When we're talking about civil arrests in sensitive locations, we're going to be looking for those guidelines and protocols that are going to be coming from the state and the Attorney General. We're going to remain vigilant if we see ICE in these areas, and we're going to be in contact with the Attorney General who can enforce this section of the law. There's also varying dates when this all becomes effective, but it's going to take some time. And the expansion of rights and tools are really the tools that are going to allow all of us to seek accountability to make this law really a reality. And so, what is next for us and for all of you? I'm going to give it back to Liv to talk about this section.
Thanks, Laura. So we can go to the next slide. And just to go back to sort of what Laura gave us in the beginning, a little history of how we kind of got to this moment. This work really started with municipalities pushing for meaningful policy reform, and the pressure that was built on the municipal level over many years really resulted in what we see in the Protect Act. And now that work goes back to the municipalities. And Laura, it looks like we lost the slide deck.
Yeah, give me just 1 second. I will
Yeah.
be right there. Okay. Oh, does not want to go there. Let's scroll through that slide. You get to look at the pictures one more time. Almost there. This is where my teenage daughter would be so helpful. She can handle this a lot better than I can. Do. Okay.
Awesome. Thanks, Laura. So like I said, the work is going to go back to the municipalities, and there is a line in the state bill, which I'll read, that says, "Nothing in this section shall be construed to require or permit a law enforcement agency to provide information or other assistance to a federal immigration authority in contravention of local or written policy of such agency." So that's a lot of legislative speak for there's nothing in this law that requires or permits law enforcement to provide information or other assistance to federal immigration authority in conflict with local or written policy. So the Protect Act is a floor, it's not a ceiling. And although local policy can't come in conflict with the state law, it can most certainly go further than the state law does. And that's really where the work that we're doing at the ACLU, along with many of our partners, is going to be turning to as we look towards the implementation stage of the state bill. We can go to the next slide. All right, so there are a few different things I want everyone here to think about when it comes to local advocacy on immigration. So the first thing that you can all do as active residents of your own communities is to find out a little bit more about what your city or town laws say regarding immigration policy. So we have evidence of roughly over 90 policies that address immigration in some way on the local level. Those aren't all good policies, but over 90 municipalities have taken up this issue in some way. And we want all of you to really reach out to your local municipalities and figure out what policies are on the books. And you can also reach out to us by filling out our interest form, and I'm going to talk about that in just a second. But you can do some of that homework on your own by figuring out what your town or city offers, and we can help you with some of the research we've already done. Additionally, as Laura said, after a bill is passed, that implementation stage is what's going to be incredibly, incredibly important. So during implementation, we need to hold our state and local actors accountable, and that work is really going to fall on all of us. And so we want you to be eyes and ears on the ground in your community, paying attention to how the different pieces of this bill plays out. And then lastly, the interest form that I was just mentioning, our Lead Where You Live Municipal Immigration Policy Interest Form. If you click that QR code, it'll bring that up. And as we embark on this next phase of immigration policy work in our state, we want to make sure that all of you are engaged in this process. So we're going to wait to see how the beginning stages of this bill plays out. I know many of folks here, including folks at the ACLU, are gearing up for primary elections on September 1st. And so we're going to turn our attention back to the municipal policy work in September. And I will pop a link in the chat to the interest form in just a moment. So if you're interested in getting engaged with us on municipal advocacy, would love for you all to take a moment to fill out that form. That'll let us know what municipality you live in. It'll help us provide any information to you that we already have about what local policy exists in your city and town, and that it will allow us to work together to hopefully plug some of the gaps that we see between the state bill and local policies. So among those 90 plus municipalities across the state that have some kind of policy on the books, they really vary. It could be that your town or city has an ordinance in place related to this. It could be simply an executive order or a resolution, could be a local police policy. And so these kinds of policies exist on the local level in many forms, and it's certainly not a one size fits all for every municipality. So this state bill really put sort of a blanket floor for the whole state about how our state is going to be interacting with ICE. But then in terms of what works best for your local community and the ways that you can go farther, might be different from community to community, might be different based on what the local politics of your town is, might be different based on who lives in your community. And we would really love to work with you at the ACLU to continue this next phase of immigration work. So let me take a moment to put that interest form in the chat box. And again, we will get back in touch with you in September after the primaries to begin this work. But please don't hesitate to fill out that form and to reach out to us if you have any questions. I'm going to put in the chat box as well an email address that you can reach us at if you have any additional questions in the meantime. So that's the link. And this is the municipal email. All right. All right, so let's turn to our questions.